Hi, this is Kip from Malik and Malik. I am going to be talking about yet another commission order. So, these commission orders are usually pretty unique, the fact patterns, because that's usually, they don't get involved unless there's something unique about um, the request for reconsideration. So, in this situation, um, this person had taken a smoke break and out in the parking lot, and then apparently they had been sitting on their foot or whatever, and their foot got fell asleep. They got up, they walked across a little bit of ways across the parking lot, and then they must have stepped awkwardly, and then they ended up getting. It doesn't sound like it's that fun. And these never are, frankly. But closed non-displaced fracture of the anterior process of the right calcaneus, tear of perineal tendon, right, and then sprain of your right ankle, and then sprain of the right foot. So the big things is they got this fracture of their foot, and then they looks like they tore their tendon in their foot. So I don't know. That sounds kind of not pleasant at all. But so they ended up filing a workers' comp claim. Ended up going to a hearing. It looks like the SHO allowed it, but the employer appealed and they requested for reconsideration. The commission granted it, and then they heard it. And then so what the full commission determined was um, basically the SHO erred when injured workers right foot ankle injuries when they determined it was in the course of and arising out of employment and not the result of idiopathic causes. So idiopathic causes are, in the context of the workers' comp world, are things particular to you. So common idiopathic things that come up are like if somebody has epilepsy and they fall. Was it caused by idiopathic? Like epilepsy, the work environment didn't necessarily cause that. Diabetes is another one that comes up quite a bit. You have diabetes, and then again you pass out. It's not controlled or whatever, and you pass out, and then you fall down and you get hurt. And then other things that might be idiopathic are just I don't know. Like in this case, this person, their foot fell asleep, right? So that's an idiopathic thing. That's nothing. The work environment, the work didn't cause the foot to fall asleep. It's just that's their body, and they sitting on their foot weird. So they kind of analyze it from a couple different standpoints. So they look at it. First of all, they're like, there were no known defects or risks associated with the surface claimant was walking. So they're looking, is there something weird about the surface? Because like if you're walking in your office and like there's carpet that's bunched up and you trip and fall because you step on the carpet or it catches your foot and you trip and fall. I mean, it seems like that'd be idiopathic, but that's really you're walking in your office to wherever you're going, to the filing cabinet or to your workstation, and then you tripped on this bunched up carpet. Well, that's not because an idiopathic thing. That's the bunched up carpet that caused that. So in this case, though, there was nothing specific, no known defects or risks associated with the surface claimant was walking on. So they're kind of looking at a zone of employment kind of situation, I guess. In zone of employment, you look at those when it's a going and coming, when you're not in your actual workplace. But they looked at that, and then the employment did not significantly contribute to the injury by placing the employment claimant in a position which increased dangerous effects of the fall. So this is kind of a get out of this claim not being a workers' comp claim card. And the way that this works is, let's say you did have like a seizure or diabetes, or if you're like me, if I'm sitting in my seat for any length of time and I get up, I get super lightheaded and kind of dizzy, and I gotta kind of sit there and like stand for a second or two to let the blood flow. If I stood up and then I fell, that would be idiopathic. That's just the weird idiosyncrasies with me. If I fell and I hit the floor then, and I like got a head injury or hit my knee or something of that nature, I fell because of, the low blood pressure, me losing consciousness, I guess, or feeling faint, and I fell because of that. Now, let's say I get up from my desk and I bonk my head on my desk. Well, the argument that I would make would be that was injured because of the risk of the work environment, i.e., the desk. Or if you work in a factory and you pass out and you hit your head on machinery, or the machinery, or anything like that, like a cabinet, anything in your environment, you would say, okay, it was idiopathic, but the work environment significantly contributed to the injury by placing me in that position. So that's not where they're going with this one. They're kind of looking at like the idiopathic, like they're looking at it more from unexplained fall case. And so an unexplained fall case is like this: like you fall and you get injured, and you can't really say why. So, and in that instance, they refer back to this Waller versus Mayfield case. And in that case, the guy fell while descending stairs, and he didn't say, "Oh, I fell and there was something on the stairway that I fell down." He's just like, "I fell down the stairs." So the argument was that it was idiopathic, and he just fell because of his own whatever. But the Waller versus Mayfield case basically explains that in unexplained slip or falls, the claimant has the burden of eliminating idiopathic causes. So if you can eliminate like an idiopathic cause, like if you eliminate, hey, I don't have diabetes, or I have diabetes, but my diabetes is under control, and I did, the test, and my blood sugar is fine, or, I have epilepsy, but I didn't have an epileptic seizure because I was taking my medication, or whatever the issue is, you eliminate that potential source of the idiopathic reason for the unexplained fall. So if you eliminate that, you present convincing evidence. Then the next thing is the case that Waller versus Mayfield case basically says, in a workers' compensation case where there's an idiopathic cause where idiopathic causes for an unexplained fall have been eliminated, an inference arises that the fall was traceable to some ordinary risk, albeit unidentified, to which the employee was exposed on the employment premises. So if you fall, if there's an unexplained slip or fall, and then you eliminate, the diabetes or the epilepsy or whatever, then the inference is, hey, it's something in the work environment causes workers injury, and therefore it should be a compensable claim. And then the final thing on the Waller versus Mayfield, they're basically saying it still does not relieve the claimant of proving a causal connection to employment. So you still have to, you have to be linked in some capacity when we're looking at in the course of employment kind of analysis. It still has to be related to the work activity or work environment or the contract for hire in some logical manner. So, i.e., you can't be showing your dad as I did in the other video, showing your dad the place where you work, and then which is a farm, and you're being chased by bees and you fall. So that's that would be a personal reason in that instance. But so once you eliminate the idiopathic causes, then you can have a lot of claim. But in this case, that person didn't eliminate the idiopathic causes, i.e., the idiopathic cause was the foot being asleep. And so that's what the commission said, hey, it was the foot falling asleep that caused her to step awkwardly and then suffer these horrible right ankle injuries. Admittedly, I wouldn't want to get those. So, and they attributed the injury to, the right leg fell asleep. So, that's kind of not a great result for that injured worker, because, you're on the smoke break, and then now you've got this kind of horrible injury that's not going to be covered through the workers' comp process, and you're not going to get comp while you're off and all that fun stuff. But nevertheless, as always, all these workers' comp claims are all super fact intensive, and so and they're all kind of these interplay of these different parts of case law and statutes and revised code sections and whatnot. So that being the case, as I always say in these videos, it's super important that you get a workers' comp attorney involved, whether you get our Malik and Malik involved, or you reach out to another workers' comp attorney in Ohio. Do yourself a huge favor. Look in Google, search for a workers' comp attorney, or ask your friends for referrals. But see who they go to, who's done a good job for them. But call an attorney or multiple attorneys if you need to get a satisfactory answer, and you need to get somebody you like working with. But get somebody involved. I just highly recommend you do that. So before something bad happens with the claim. So you've been listening to Kip from Malik and Malik. Hopefully you found something helpful in this video. Thanks for watching.